Please the court. Brandon Breslow, Kynes, Hartman, and Feldman, along with Kristen Norris on behalf of Betty Baxter for the estate of Brian Baxter. There reserved 5 minutes for rebuttal.
Okay.
This is an appeal from summary judgment in a wrongful death case that involves a high-speed collision on a pitch-dark highway.
And the disputed issues of material fact which jump out at you when you read this are whether or not the truck trailer in question was illuminated.
That is correct, Your Honor. That is issue number 1 and issue number 2, and that's based on the eyewitness testimony of the 2 drivers who are behind the truck driver viewing the collision itself occur and saying that had the trailer been illuminated, we would have seen it.
And nobody else testified to the contrary.
No, Your Honor, there were no other eyewitnesses to the collision who testified that the trailer was illuminated in any way.
The driver saying he checked him out before he left.
Yes, Your Honor. Yes, Your Honor, that's correct.
And even if they did work in the parking lot before he left, that doesn't mean they were working when this happened.
Yes, Your Honor, and also that the trial judge found that that testimony by Mr. Preston was uncontroverted, but that is still a jury question, Your Honor, in light of the eyewitness testimony about the lights not being illuminated at the time.
That also was uncontroverted, right?
Unrefuted, yes, Your Honor.
Okay.
I think those two things are materially disputed to create a genuine dispute of material fact for the jury on the issue of whether or not the lights were illuminated at the time of the collision.
But both of those drivers said, gee, I wasn't really paying attention because it was happening so fast and I was worried about what I was doing. And the trial judge placed a lot of emphasis on that.
Your Honor, what they said, I'll take each eyewitness in turn. What Ms. Johnson said was, I was not paying attention to the trailer because the trailer couldn't be seen. There was no reason to pay special attention to the trailer when it was on.
She did say I was avoiding the accident. And you don't agree that that's chronologically difficult to swear because she couldn't avoid the accident until it was happening.
Yes, Your Honor, that's correct. When she's not paying attention.
I wasn't paying attention because I couldn't see it.
I'm sorry, Your Honor.
You just said Gaines said what the panel said, which is, he said, well, she just said, I wasn't paying attention because I couldn't see the truck. But that's not all she said. She said I wasn't paying attention because I was trying not to get in an accident.
At the time the impact occurs, Your Honor, when she thinks this car has essentially exploded, which is not what happened. She says, I'm then focused on getting onto the side of the road, and she does eventually help the Daniel Baxter.
Truck driver herself, right?
She is a professional truck driver, Your Honor. She says, had she been in the car that the Baxters were driving the Toyota Corolla behind the trailer, that she would have gotten that same accident or could have gotten into that same accident. Your Honor, what Ms. Johnson says when she discusses about not paying attention, there's no reason for her to pay special attention until the collision occurs. But what Ms. Johnson also then says is that had there been lights or brake lights used by Mr. Preston at the time of the collision, she would have seen those. And so the reason that their trial judge places emphasis on that testimony is that it's taken out of context. Now, Your Honor, and along those lines, the trial judge erred when it rejected that testimony based on its finding the eyewitnesses were not paying close attention. And at a minimum, the strength of their testimony, as we pointed out in the briefs, is a jury issue. It's a credibility one that's improper for summary judgment. As Judge Morris said in the last opinion, which was filed as notice of supplemental authority, the general bedrock principles of summary judgment are for trial judges not to weigh the evidence or make credibility determinations. And that applies in this case, in particularly in the way the trial judge entered its order. It goes through and says and doesn't point out the testimony of Ms. Johnson or Mr. Vaca, who was also an eyewitness, and said they did not see truck lights illuminated on the truck, but did see the collision, which is all that needed to be in the record evidence to survive summary judgment in this case. The trial judge says, well, they must have just been trying to avoid the accident, but that's not all the witnesses said. They did describe that they would have seen the brake lights had they been illuminated. The defendant's answer brief in particular illustrates that this is a factual dispute that jumps out of the way that it sort of wrenches snippets from the testimony of Ms. Johnson and Mr. Vaca. But as we just discussed, the entirety of that testimony shows that had the truck lights been illuminated, these witnesses would have seen it. They weren't illuminated. And that testimony itself is enough to dispute Mr. Preston's testimony.
I don't know that they go so far as to say that they weren't. I think they say that I didn't see the truck until I came up on it. I probably would have seen it if I remembered seeing lights. They don't, I don't know it's so certain as like 100% I didn't see any lights as typical in all testimony as far as 100%, right? So, but to your question, whether there's an issue of material fact here. So, I guess I had a question because it seems to me that the trial court kind of generalizes and lumps these two witnesses together in that paragraph in the order. And I had a question as to the emergency flashers. I believe that only came from the testimony of Mr. Baca. Or was it in Ms. Johnson's testimony? I don't think it's in both.
Your Honor, there was testimony and questions about whether the emergency flashers were engaged after the collision occurred, and there was also a dispute below about whether the emergency flashers should have been engaged as the collision occurred or as Mr. Preston was coming up.
And that's very different than what we're talking about here, which are the actual brake lights, correct?
Yes, Your Honor, the law that requires that the tractor trailer both engage in brake lights and tail lamps
But
at
there
the
is no
time
law
period.
that requires these hazard lights to be put on.
As far as we know, Your Honor, there's nothing in the Federal Carrier Act that was part of different negligence claims or different negligence theories brought below, but that's not an issue of general negligence
Unfortunately,
here.
the evidence that the deceased didn't slow down until just before the crash seems to support the inference that there were no lights, doesn't it?
Yes, sir. Well, unfortunately, you use that, yes, Your Honor. That's unfortunate for the
It's
circumstances.
terrible, but, I mean, the evidence is he braked at the last minute.
The last 1.5 seconds before collision.
In the dark and in inclement weather.
Yes, and that's entirely a reasonable inference that a jury could find in the favor of the Baxters on their claim of negligence, because if in the pitch dark, the brake lights would have turned on in at least 5 seconds, given them the notice that they needed. But also, Your Honor, that proceeds to the second theory of negligence here about how Mr. Preston did operate his motor vehicle leading up to the accident, sort of even if the brake lights were illuminated, which we don't contend they were.
So on that one, to rebut the presumption, you need evidence of negligence.
On the lead driver's part.
Yeah. So what cases can you point me to that support under these facts? Which I understand that I'll be a crude summation. You're the better advocate, so you could correct me. The facts are he should have slowly applied the brakes instead of letting off the gas.
That is one factual certainty.
Which inevitably led to the necessity of slamming on the brakes later. I mean, that's negligence. I mean,
Yes, Your Honor, in part. So Your Honor brings up what the body of case law might be about the ability of what this driver should have done when they're coming upon potential danger ahead of them, and there are cases that discuss that.
I don't want to interrupt you answering his question, but I want to point out to another issue related to his question and let you address it. If you let off the gas of a vehicle, you're not hitting brake lights.
Yes, Your Honor, you're
That's
not.
the danger of slowing down. Cruise controls are like that. Just taking your foot off the gas is like that. The driver to the rear is not warned because they don't see brake lights. That could be what happened in this case, which is why no brake lights were seen, because he attempted to slow down, not by using his brakes, but by taking his foot off the gas.
Exactly, Your Honor. And in context, right, this is a 80,000-pound tractor trailer and driving in front of a Toyota Corolla. The witness testimony, I believe it was Ms. Johnson, said you didn't see the vehicle that was in front of the trailer driving behind the trailer that eventually goes into the road because of the sheer size, well, also it's pitch dark, but the sheer size of the tractor trailer that Mr. Preston's driving. So the fact that no brake lights over the course of 8 seconds of coasting were used by Mr. Preston, had they even been working, would have given warning to Mr. Daniel Baxter driving the Corolla for them to be able to know that there might be some danger ahead of them, which Mr. Preston knew over 8 seconds. The negligence here in how Mr. Preston operates is that, and this is shown from the dash cam footage in conjunction with Mr. Preston's own testimony, is that he knows he needs to slow down. He knows he needs to do something because there was a danger ahead of him. And instead, thinking that his coasting would bring him down to 15, 20 miles per hour fewer than he was going at that point. He was-
Miles an hour or 70 or something like that, and that.
He was, sorry, Ryan.
On the dash, whatever it is on the dash cam.
He's starting at 68 miles per hour once he's coasting, but his truck, also the evidence in the record is that his truck tops out at 70 miles per hour. I mean, he is going as fast, almost as fast as his truck would allow him to go on the highway. And then thinking that he knows that coasting should reduce his rate to 15 or 20
He
miles per
also
hour.
said, though, which is concerning, that he was really focused on trying to avoid the vehicle pulling out in front of him. It never occurred to him that there was going to be any issue with vehicles behind him.
Absolutely, Your
I thought
Honor.
that was a very surprising statement for a truck driver to make.
A truck driver with over 20 years of experience and driving 2 million miles on the record is what he explained. It is very concerning, Your Honor. I mean, Burge, the Florida Supreme Court decision that we believe controls this case, it should control this case, in terms of the comparative negligence aspects of this, talks not just about the duty drivers owe to the cars in front of them, but also to the drivers behind them. And we think that applies with special force with a tractor trailer like Mr. Preston is driving. They're driving, I mean, as we said, the tractor trailer controls the line of vision of the cars behind them. And so it is especially important, and a reasonable jury can conclude this, that Mr. Preston should have at least, if he thought the lights were working, flashed his brakes to let the driver behind him, if there were any drivers like Mr. Baxter or others, to know to slow down.
I know we're kind of focused on the brake lights, because obviously those illuminate a different color, okay? But there was some testimony from the witnesses that they didn't even know there was a truck in front of Mr. Baxter's car. So my question is, what was the testimony on the lights of the car, of the truck?
So, Your Honor, actually, I was going to go back to that because in Ms. Johnson's testimony, I'm looking at pages 841 to, just make sure I'm doing this one, sorry, 811 to 813 of the record with Ms. Johnson's testimony. She does say, I didn't see any lights whatsoever. I didn't see any brake lights when the car hit the back of the truck. So the testimony there is that if there were no brake lights, I didn't see any lights whatsoever, would also include tail lights. Your Honors, in regards to the argument about negligence, I do just, on the second negligence theory here, in addition to the brake lights of what Mr. Preston is doing, I wanted to continue on to say that there would have been no need, as Judge Atkinson brought up, for Mr. Preston to stand on the brakes as he explains it and go drop his rate of speed from almost the near top of his capacity his truck could handle, to 70 miles per hour, by 54 miles per hour in about 5 seconds.
You know, the tough part about focusing on his behavior is we're looking at a window of seconds, right? It's about 10 seconds.
Your Honor, in total, it's about 13, and I don't mean to parse hairs here.
Okay, so I'll go with 13.
30%.
That's still, you know, I mean, it's hard to sort of find fault with anything he did in a window of 13 seconds.
A reasonable jury could find fault in that. And the
Let me
reason,
ask you, so sorry to interrupt you again, but it could find fault. I know that what, looking at an expert from Burge, you know, I know it says, you know, evidence from which a jury could conclude the front driver was negligent. I mean, but you're overcoming a presumption. I mean, you just need just something that the jury could find by a bare preponderance, could prove negligence, and they could say, yep, the presumption's over, is rebutted.
Your Honor, no. Your Honor, no. There's not the issue as Burge and argued in the briefs and explaining the briefs. Burge is about the presumption dissipating if there is evidence of negligence, any evidence of negligence by the lead driver. There are the cases that discuss the issue of overcoming the presumption of rear-end negligence by some cases about whether it might be an illegal stop, or in this case, the presumption is, we believe the presumption.
Some sort of reasonable explanation though as to why they weren't negligent?
Your Honor, no, not under Birch, not under Birch. The presumption does not need to be overcome as in prior case law pre-Birch, the cases that are used by the defendant's answer brief. It's the fact or evidence of negligence by the lead driver, in this case, Mr. Preston, where the presumption dissipates altogether.
I think I understand the distinction you're making. In other words, maybe I missed up, but I didn't mean to say that a bare preponderance and then the presumption of negligence on the rear driver goes away. You're saying that all we have to focus on is that if the front driver was negligent at all, it's a jury question because it eats into the 100% fault of the rear driver.
Absolutely, Your Honor. And that's actually
My question is, how do you get there? Is it just like I mean, I guess I got to take it at face value. If any juror could say, yeah, you were a little tiny bit negligent, then it goes to the jury.
Yes, Your Honor, that's the comparative negligence scheme that operates in this
If
case.
there's some world in which in these 13 seconds, we could find some sort of misjudgment on your part and you breached a duty to your rear driver, then we go to the jury.
Well, that's the negligence claim, Your Honor. Then under the comparative negligence scheme that is applied in Verge as applied in other negligence cases, and it doesn't have to be just any world of facts, right? There's been evidence presented here from which a reasonable jury can conclude that Mr. Preston was negligent because he views the scenario in front of him as a danger, knows he needs to reduce his speed, and doesn't do so. Now, we know his truck can reduce that speed because he's standing on the brakes, as he puts it, over the course of 5 seconds, or that he just should have flashed his brake lights and given warning to the Baxter's Corolla behind him that they needed to be aware of potential danger ahead of him. It's possible, the record does not descend into these details of what the Baxters could have done if they saw the brake lights and slowed down those cars, but frankly, the inference from this case goes back to the prime negligence theory here, which is that Mr. Preston was operating an 80,000-pound tractor trailer without his brake lights or tail lamps being illuminated. And that was sufficient, and there was no basis for the trial court to find otherwise, because that's improper on summary judgment. Everything the trial court pointed to was the weighing of evidence and credibility issues that ultimately go to a jury. The jury has jury instructions that decide whether
You're starting to encroach on your rebuttal time, but it's your time. I just want to warn you.
I appreciate that, Your Honor. To just conclude my thought here, the jury instructions do talk about the believability of witnesses and the things the trial court brought up about whether or not these witnesses could have viewed the accident or didn't view the accident, or our ability to perceive, ability to recall certain facts, and those are classic jury questions. Your Honor, I will save the remainder of my argument for rebuttal, but I will just say that the evidence, if we believe the evidence presented by the state in this case is sufficient and viewed in its favor as the law required, would show that Preston either failed to ensure that the trailer was illuminated or failed to decelerate his 40-ton truck in a controlled and effective manner after identifying the dangerous hazard ahead of him. Or the remainder of my time.
You'll have 4.5 minutes.
Good morning, Your Honor. May it please the court. My name is Michael DeLugo from the law firm of Whipper Smith in Orlando, and I represent Venecia Trucking and Mr. Preston. Obviously, given your questioning of my colleague here, it's very clear that we have two very clear issues that we're talking about here. One is whether or not the trailer was illuminated in the moments prior to this accident, and the second is whether Mr. Preston himself was negligent in the manner in which he slowed his vehicle down.
It looks like the trial judge acted as a jury and made a credibility determination and found some facts.
And I disagree with that.
Okay, well, I expected you wouldn't. I want to give you a chance to tell me.
Thank you. Really what this comes down to is timing. Okay, so with regard to the illumination of the trailer, the only testimony that was presented to the lower court of whether the lights were functional was Mr. Preston's testimony himself that he conducted a pre-trip inspection of the vehicle and the lights were working. Okay.
Let me ask you this: how does I'm not saying the record supports this, and it's a theoretical question, but reject it if you think it's outside the record. how does a truck driver, without a partner, determine whether his or her brake lights are working?
As a practical matter, I do not know. I can't answer that. It
One thing is
is,
saying, well,
a
when-
logical
when I was
conundrum.
in the rear of the trailer and I didn't
That's an
see.
excellent question.
I didn't see the,
no, I thought about that as well, and there is no record to indicate how that works.
It's unrefuted. It's unrefuted. He had-
That's correct. That's correct. How that actually worked as a practical matter, I do not know. I think you're right. I think you would have to have a partner to confirm.
we did, and well, this you can educate me on, I don't remember. Did Mr. Preston testify that my brake lights were working, or did he just say generally, yeah, I didn't check and there were lights?
He testified that he conducted his pre-trip inspection and that the lights were functional.
Or he didn't say,
He didn't go into specifics as to each
brake
individual
lights
light.
versus running lights.
That's correct.
The only testimony on any brake lights comes from the witnesses, Baca and Johnson. Is that right?
The only, yes, so
Okay.
getting back, I'm sorry, go ahead.
Yeah, well, I'm focused on paragraph 16 of the order, because it seems to me that the trial court makes this overgeneralized statement lumping the deposition testimony of these two eyewitnesses, and then focuses on the emergency flashers, and ignores their testimony about brake lights during the accident. So help me out how, or didn't do what I just said it did.
Sure, so the issue really comes down to timing, okay? Both Mr. Baca and Ms., I'm blanking on her name, the other witness, Don Johnson, thank you, both testified that they weren't paying attention to those vehicles prior to the accident. And the issue is, what did the brake lights function prior to the accident? And it just makes logical sense that they're not paying attention to, they're focusing on their own driving. They're driving their vehicles. And Ms. Johnson said that she didn't know what was happening until it happened. So, and Mr. Baca.
Did she also say that, if I were Mr. Baxter, I probably would have crashed too, because I couldn't see the truck.
She did say that. But the issue is, was this vehicle illuminated, or was the trailer illuminated? And she testifies that she wasn't paying attention until the accident actually occurred. So there's no testimony to contradict Mr. Preston's testimony that the lights were functional prior to the accident. Both the eyewitnesses, Mr. Baca and Ms. Johnson, only testified to what they saw after the event occurred.
Now,
Go ahead, Judge.
there's a question, I believe this is Mr. Baca, at any point in time, either before the collision or at the time of the collision, did you see the truck empty? Because they're hazard lights, no, they were never on. That they were talking about coming up onto the truck itself, not seeing any lights. So isn't that an issue for the jury, that whether or not that truck had any lights at all, whether they be brake lights or just their lights on during a very, very dark part of the day? Isn't that a matter and a question for the jury?
I think there are flaws in both eyewitnesses' testimony that allow the judge to make the decision that was made here. First, with regard to Mr. Baca, he testified that when this accident occurred, he was 500 meters away. So anything that he's not testifying to what the illumination of the vehicle prior to the accident. He can only testify to what he sees once he drives that 500 meters and comes even with the accident. And the same is true with Ms. Johnson. She testified that she wasn't paying attention until the accident occurred. So the trial judge in this case, I think, was correct in concluding that there was no contradictory testimony to Mr. Preston's testimony about the lights functioning until after the accident occurred.
Well, if that's an inference, though, that's an inference that the jury would have to draw, that she didn't see lights that were actually there because she wasn't paying attention. But couldn't the opposite inference also be drawn, which is that I didn't notice the truck because there were no lights? And if so, isn't that a jury question?
But then she testified that she wasn't paying attention until the accident occurred. So again, I keep on coming back to the issue of timing and the fact that the only testimony elicited from these two eyewitnesses are what they saw after the event occurred.
Well, the problem with that is that the human senses sort of vary on a focus and a periphery. And it sounds like her focus was driving her car. But when asked about it, her peripheral memory was, oh, by the way, I didn't see any lights on that either. I mean, it's not like you can only see one thing at a time. None of us do that. We see multiple things at the same time. And that sounds like what this testimony is. My focus was on making sure I wasn't involved in the crash, but oh, by the way, I didn't see any lights on that truck in the periphery of my field of vision. So, and at night, your lights are gonna be really present. You know, it's not like daytime where you're not sure if you see lights or not. At nighttime, they're either gonna be there or they're not.
Understood. I'm sorry, was there a question? I wasn't.
Well, I want you to respond to that if you disagree with it.
I don't disagree as far as, human nature, although there was no human factors testimony, no expert witness in human factors in this case. But that is true, we all have the general knowledge of how our vision works. But again, I would say that the testimony from Ms. Johnson was that she wasn't paying attention until this occurred.
Well, that's the problem with the trial judges seizing on that comment. The dichotomy that I just explained to you. Her sole focus wasn't the back of that truck. Her sole focus was, I don't want to get involved in this accident. And in the periphery, she recalls not seeing lights. That's the problem with what the trial judge focused on, I wasn't paying attention. And like that was the end of the story. Well, the jury would have the opportunity for lawyers to argue the things that I've just laid out to you about why what her sole focus was isn't necessarily the only thing she could perceive. There's other things that she could perceive. That's the problem with, the way this got, rendered.
This is the question I have, because if the court is only focused on the statement of not paying attention, it's ignoring the deposition testimony and disregarding it, possibly on credibility grounds or whatever. But one of the questions to Ms. Johnson was, is there any reason you can think of as to why you didn't or couldn't see the cement truck ahead of you? No, I would notice if someone put on their brakes or anything. And so, I mean, there's an explanation there as to why she might not have seen the lights, because there was no brake lights that were engaged. And so isn't that something that the court missed in its findings and ignored and focused more on one part of the deposition testimony? Because that is a fact, would you not agree? That would be, let's say we don't have paying attention, isn't that an issue that should have gone to the jury?
And obviously, advocating my client's position, I would say no.
But if someone should engage if someone's supposed to engage their brake lights in something like this, and is that negligence on the part of the cement truck driver? That should have gone to the jury to determine whether that driver was negligent or not.
Okay, is the question whether or not the truck driver was negligent in the manner in which he operated the vehicle, or in the mere fact that the assertion that there were no brake lights that were functioning at the time?
Well, either one of those.
Okay, well,
either one of those.
So if the testimony, if the inferences that are being drawn are that the brake lights were not functioning at the time, I would argue that testimony is, that the judge, I think, came to the proper conclusion just based upon the fact that, and I understand Judge Morris's statement with regard to peripheral vision and seeing things not, what you're focused on. But again, I keep on coming back to the issue of her testimony stating that she was not paying attention. And this is human, that's also human nature.
It sounds to me in the order that the judge sat as a seventh juror and decided to take parts of that testimony and ignore other parts where she said she didn't see lights.
And I respectfully disagree.
I understand your position.
It's important that, my knowledge of the record is not comprehensive, but that she always the witnesses qualified their lack of attention. I wasn't really paying too much attention. And even the judge, in one of its findings, the trial court said it wasn't paying close attention. I don't think the court made a finding that they were completely oblivious. Shouldn't we take that?
Right, you're right. The page 820 of the record, she states that I wasn't really paying too much attention.
In other words, that means there's not a complete dearth of attention. It was just, wasn't as close as it could have been. Should that matter?
I don't believe so.
Can I ask you a question about the alternate theory? Should it matter, or does it matter to support the argument that the witness himself, the truck driver, professed an intention to slow the truck down a certain amount and admitted that his course of action didn't slow the truck to the degree he had hoped it would?
Well, the issue again comes down to timing. So when Mr. Preston perceives the danger, it's still out of the right of way, okay? And that's when he makes a decision to take his foot off of the accelerator and to go into cruising mode. And that goes on for 8 seconds. So that was appropriate given the circumstance.
But isn't it evidence of negligence that he said, this is what I intended to accomplish by taking my foot off the gas pedal, and that didn't happen. In other words, he made a calculation that if I take my foot off the gas pedal, I will decelerate at a rate that will, ensure safety. And he admitted, well, the deceleration wasn't as effective as I intended.
I don't think that his lack of accuracy with regard to the amount of velocity that is lost by taking your foot off the accelerator versus braking constitutes negligence, especially under these circumstances where, again, he perceives a hazard but off the road. And that's why he intends to reduce his speed by taking his foot off the accelerator. It's not until the vehicle that is outside of the right-of-way enters the right-of-way, that's when he applies the brakes. And I think that was perfectly reasonable.
And that's what the bilge says. Anyway,
it's bilge versus Sharon.
Yeah, it says just evidence from which a jury can find negligence. I mean, an analogy would be, say, a doctor in Med-Mal case said, I put 4 sutures because typically that I thought that would stop the bleeding, but it didn't stop the bleeding as much as I had expected it to. Isn't that evidence from a jury that this doctor in his professional judgment said, I thought this would work, but it didn't?
I think that the professional malpractice analogy doesn't work in this case. I think that under the circumstances, especially here where you've got a video showing what the Mr. Preston is seeing and his actions in response to the hazard that he is seeing were appropriate. And I think that the judge under these circumstances was correct in finding that Mr. Preston was not negligent as a matter of law, and therefore the Burge decision is not triggered. And so we're just left with the inference of negligence.
I'm more troubled by his actual admission of negligence and said he wasn't concerned, didn't have a clue what was going on behind him in a rear-end collision case. All he had to do was look at his rearview mirrors and see these cars bearing down on him. Presumptively, he would have done something to alert him or warn him or something.
But I don't think he can.
Basically said, I didn't even think about it.
But he can't be held to be negligent if he has to choose between the accident in front of him or the accident behind him. He can only respond to the visual cues that he has in front of him. If his concern is more about what's in his rearview mirror than what is in front of him, that's negligence.
It just is difficult for me to comprehend that any driver who's coming to an abrupt stop on a highway doesn't, among the many things they do in the few seconds they have to react, is look in the rearview mirror and see what's behind them.
And I think that this accident happened too quickly, or this hazard appeared too quickly for him to do anything other than what he did.
I agree, 13 seconds, whatever, how many seconds is not enough time to even think about what you're going to do, really. So, I mean, I do understand that part of it.
The two issues, I think, with regard to whether Mr. Preston himself was negligent is, I think, a non-issue because he did what he had to do under the circumstances. We would argue that the presumption of negligence on the part of the rear driver has not been overcome in this case. We would ask that the court affirm. I'm happy to answer any further questions. Otherwise, we'll rely on the brief.
Thank you.
Thank you, Your Honor.
Please, the court.
Sir.
Thank you, Your Honor. Your Honor, there's three reversible errors in this case, and the court has a firm grasp on the facts. The first being that the trial court weighed the testimony of the eyewitnesses and sat, as Judge Smith said, as a seventh juror. And that was improper under the bedrock principle of summary judgment. This has operated in the new standard, and that's explained in the Lassiter opinion thought by us as supplemental authority. The one thing I want to bring up about what my colleague said in response was that this is something that there's flaws in the eyewitness testimony. And I think that speaks for itself in showing that these are credibility determinations that should have been for a juror. They weren't for a judge. And the flaws are just, they're not even that. They're qualifications made in the course of deposition testimony that the trial judge failed to consider in the entirety of the context. In particular, the statements by Ms. Johnson that she would have seen brake lights had they been illuminated. The theory of negligence that this tractor trailer was driving in a pitch dark highway without tail lamps, without brake lights, in the dark. It's a classic negligence question for a jury and one that should have survived summary judgment. The second reversible error was the judge's finding that this driver acted admirably. That's what the order says, and that the stop was sudden. But there were calculated moves by Mr. Preston explained in his deposition testimony, as Judge Atkinson brought up in questioning to my colleague here about what Mr. Preston thought should have been done in the time period. And that testimony, taken in conjunction with the dash cam footage, is also sufficient evidence for a reasonable jury to find that even if the brake lights were working, the testimony unrefuted is that they weren't. Even if they were, they should have been used to alert the Corolla behind him that the Baxters were driving in, or that he should have operated his tractor trailer in a slow and controlled manner in order not to stop. The argument that my colleague made was that Mr. Preston can't be held responsible for avoiding the crash ahead of him and also avoid the crash behind him, but the Supreme Court has said otherwise. There's a duty not just to lead drive, to make sure that there aren't incidents of negligence to drivers ahead of someone, but also to the drivers behind him. And Mr. Preston pointed out that he wasn't even concerned with the drivers behind him. And that's what happened in this case, is that lack of concern is what led the Baxters to a sudden impact with the back of the tractor trailer. The final reversible error in this case is the misapplication of the presumption of rear end negligence. The trial judge's order itself says that essentially what the plaintiff must prove is the lack of any negligence on their part, but we are in a comparative negligence scheme, and that's what Burge applies. So for those reasons, we ask the court to reverse and remand for a trial on the merits. Thank you.
Thank you. Thank you both very much. It's a tragedy in this case, but you both did a fine job arguing, and I appreciate it.
Thank you, Mark.